Welcome to Moving Forward Together, Family and Immigration Law Podcast.
Welcome back to Moving Forward Together, Family and Immigration Law Podcast. I'm Lisa Mosby, and today we're here with attorney Damian Crooks of Zuma Law. Damian is a founding member of the firm and has represented thousands of clients in family-based immigration, humanitarian relief, and deportation defense matters since 2011. Today, we're breaking down immigration waivers. Damian will explain what a waiver of inadmissibility is, who may qualify, and how these waivers can create a path forward when immigration says someone is not eligible. Damian, are you ready to go?
I'm ready.
Let's get started. Could you explain what a waiver of inadmissibility actually means?
Sure. So to understand what a waiver of inadmissibility is, you have to understand what are the grounds of inadmissibility. Basically, under the Immigration and Nationality Act, there are certain things that could have happened in the past that make someone ineligible for either resident status or even to enter the country. And those are called the grounds of inadmissibility. So if a person is subject to the grounds of admissibility, sometimes those grounds can be waived if an individual submits an application and meets certain criteria.
And then what are some of the most common reasons someone might be considered inadmissible in the first place?
Sure. The most common we see is unlawful presence. If a person has been in the United States without lawful presence and they leave the country, they can be subject to different unlawful presence bars. In addition to that, we see fraud, where someone has either misrepresented themselves at entry to the country or they've submitted an application which had contents in it that was not accurate and truthful. Or we see certain criminal grounds of inadmissibility. Someone has been convicted of a certain crime that makes them ineligible to proceed without a waiver.
And then are all grounds of inadmissibility eligible for a waiver, or are there certain situations where a waiver simply is just not available?
So this is actually a compound question because there are some grounds of inadmissibility that generally are not waivable in a general waiver for family-based immigration or employment-based immigration, but might be eligible for a waiver like a non-immigrant waiver or an exception to the general rule. But generally speaking, for example, if someone had claimed to be a U.S. citizen after September of 1996, or if someone has certain controlled substance convictions outside of marijuana under 30 grams, they're generally barred from moving forward and there is no waiver available. But again, they might be eligible for a non-immigrant waiver, which we'll talk about a little bit later on.
So one concept that people often hear is extreme hardship. What does that mean in the context of immigration law? And who does that hardship have to affect?
Yeah, so generally, a lot of waivers have this concept of extreme hardship, where you have to show extreme hardship to a qualifying relative if you're not allowed to be come into the United States or stay in the United States, and you must relocate to your country of birth. The concept of extreme hardship was created by Congress, but wasn't really defined, and it really has been threshed out in case law. Generally, when they look at extreme hardship, when they're making a decision whether or not a qualifying relative might suffer extreme hardship, they look to five major factors, and that would be the qualifying relative's health and how would their health be impacted if they had to relocate with the applicant to the country of birth, or if they would be separated. They look at also emotional hardship. What would the emotional impact be to the qualifying relative if their loved one and family member was not allowed to immigrate to the United States or was forced to leave? They look at financial hardship. What would the financial impact be to the qualifying relative? In addition to that, they look at family hardship. What would the impact be to the whole family unit? For example, if we had a couple and the qualifying relative was a spouse, if they had a child, that child would suffer without one of their parents. Although the hardship to the child itself is not directly qualified, we basically can show that a parent loves their child, and if their child suffered, they would suffer. And then last is social hardship. Social hardship is really where they look at the location where the person would live if they were not allowed to immigrate to the United States or was forced to leave versus where they would live here. And what's the difference between those two locations? Is there economic factors? Is there violence? Is there crime? And how does that impact the qualifying relative?
And when you say they would look at, are we in a court case, or is this stuff that's happening in meetings outside of the courtroom?
Yeah, so generally there's two different governing agencies that might adjudicate a waiver. If you're in, court or in removal proceedings, that would be the EOIR. EOIR is the immigration court, Or if you're not in court, oftentimes USCIS or the Department of Homeland Security would be the adjudicator of a waiver of inadmissibility.
And then, Damien, what types of evidence tend to make the strongest case when someone is trying to prove extreme hardship to a qualifying relative?
Yeah, generally, there are 5 factors, and those factors are looked at in the totality of evidence. But generally, health hardship is one of the largest ones they look at. Medical records from the qualifying relative. Do they have any health conditions that they wouldn't be able to get treatment for in another country? How would they be impacted if they're be separated? We also have affidavits, letters from individuals, especially the qualifying relative themselves, explaining why it is they need their family member in the United States. Other individuals that might have witnessed the relationship and why the family member needs to be here. Country condition evidence, where the country of relocation is, what's going on the ground there. Is there violence? Is there, poverty? As well as, proof of legal status of family members and showing that family members are located in the United States. So those are common types of evidence we're putting together.
And that's really a lot of legwork. Does your firm handle those things? Do they, the clients have to find and discover all that information? Give us a little bit more about this process, because there's so much involved in gathering the evidence needed.
Yeah, waivers are really a teamwork effort. It is a lot of work for the clients to get various things. And our job, when we're filing a waiver, is to work with the clients to identify what are the strongest possible arguments we have and help guide them to get, the evidence they need. In addition, we're generally helping, clients and their qualifying relatives draft their affidavits, what type of things that are important to put in those. But it really is a joint effort to make sure that these things are approved.
And then how does that waiver process typically unfold? What should families expect in terms of the forms, the timelines, and maybe the government review?
Yeah, so waivers actually come about in 2 different ways, okay? Very often, an individual will come to our office for an initial meeting to discuss, fixing their status, and we'll determine from the outset that they need a waiver, and we know that, hey, we're going to file this application on your behalf, and we're going to need this waiver because you're inadmissible for this reason. The other way it comes up is sometimes individuals will be filing a case on their own, or they'll be filing it with someone else, and all of a sudden they go to their interview and they're like, they find out you're inadmissible and you need this waiver, and now we're on a rush to kind of file it. But generally, everything starts with an initial consultation with their office, identifying what people are eligible for, what's the strongest approach to their case, what are their strengths and weaknesses, and then really putting together, these applications together and filing with immigration. Unfortunately, post-pandemic, a lot of the waivers of inadmissibilities have extreme backlogs, which is really frustrating. Unlawful presence waivers or 601As or fraud waivers right now are taking almost 2.5 to 3 years for immigration to make a decision on them, which can be very, very frustrating. But it really is just putting together, because you got to wait that long to make sure everything is approved and we're putting the best application forward.
And you mentioned unlawful presence, and in some situations, people may need a waiver because of unlawful presence or maybe prior immigration violations. How do these cases differ from criminal-based inadmissibility issues?
Well, there's different types of waivers. For example, someone that has been unlawfully present in the United States and left the country and came back, they may be subject to something called the permanent bar, which is basically they have to leave the country for 10 years in order to waive their ground of inadmissibility. Now, for those individuals, the waiver standard is completely different. It's not an extreme hardship waiver. It is a family unity waiver, where opposed to criminal waivers are generally extreme hardship waivers, or at times they can be, if the crime occurred more than 15 years ago, a rehabilitation waiver. But generally, the criteria can be different, and also the discretion is different. Obviously, a criminal waiver a lot of times has a lot more discretionary factors where you have to prove a lot more than you do for the unlawful presence waiver.
I always ask for an example. So can you share an example, maybe something common that happens of a case where someone initially thought their immigration history permanently blocked them, but a waiver created an opportunity to move forward?
What we commonly see, which is in practice, is individuals might have been barred for an immigrant waiver, like to apply for a green card. As we talked about there, before, there are certain things that you can do. For example, claiming to be a U.S. citizen, or certain controlled substance violations that would make someone ineligible for the green card through like a family member. But those individuals still might be eligible for a non-immigrant waiver, which is a lower bar. For example, individuals are victims of crimes, U visas. they can qualify for a non-immigrant waiver, which basically it can waive anything as long as discretion is warranted in their case. So you have to see that a person might come in and they're wanting to fix their status through their spouse, and we determine they can't. But then we, by doing an intake process, determine they might have been a victim of a crime a long time ago, and they're eligible for this other waiver that can waive the ground that is a concern with the family-based case.
Damian, I want to wrap this up for folks. So for someone who is unsure whether they need a waiver or whether they qualify for one, what is the safest way to approach that question before filing anything with immigration?
So to start, generally if someone is coming to our office before they're filing an application, it's our job really to try to determine what the final outcome is going to be. So I always start with a consultation. If you come in, we pride ourselves on being honest. We're going to tell you if you're eligible or you're not eligible. If you are eligible and you need a waiver, we're going to identify, what we think is your likelihood of success. So I always say everything come in, meet with us. We'll be honest with you. We'll tell you the truth and kind of guide you through the process as to whether or not you're able to move forward or not. And if there is any risk, what type of risk you're looking at.
And what does it cost to have a consultation, and how long does it usually take?
Yeah, so our office normally charges $150 for a consultation. The consultation itself is generally 30 minutes to an hour, depending on various factors. But it's really a giant assessment of your overall immigration case. Like I said earlier, sometimes an individual might come in thinking that they're going to file through their spouse or their child. Then we determine that they're just not eligible for that, but they might be eligible for something else.
Great insights. And folks, it's a small investment to find out what your situation is. So we encourage you to reach out and get the information, get help if you need it. Damian, thanks so much for your insights today.
Thank you. I appreciate you.
That's a wrap up of today's episode, Moving Forward Together, Family and Immigration Law podcast. To learn more about Damian and the immigration services he provides at Zuma Law, visit zumalegal.com. Thanks for listening. And don't forget to leave a review, and subscribe to the show so that you don't miss the next one. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.